On October 14, a district court for the Northern District of California granted summary judgment in Scholl v. Menkewen, a case that challenged the IRS's policy of excluding inmates from receiving $1,200 stimulus checks. The court also made permanent the preliminary injunction it had issued earlier this month, which means that the IRS and Treasury Department cannot withhold stimulus checks solely based on an individual's incarceration status. The government could still appeal the court's ruling again. It was denied by the Ninth Circuit, but the permanent injunction should be cause for celebration for the over 2 million incarcerated individuals in the U.S. who may now be eligible for an economic impact payment. The case was initially filed on August 1, 2020 in response to the IRS unilaterally deciding that incarcerated individuals do not qualify for a stimulus check. In an answer to a frequently asked question on its Economic Impact Payment Information Center, the IRS wrote in May that payment made to someone who is incarcerated should be returned to the IRS. Many legal experts challenge the basis for the IRS's move, arguing that it acted beyond its authority, perhaps even illegally. There is no mention of incarcerated individuals in the CARES Act, which some argue makes the IRS position wrong because it contravenes the clear text of the Act, according to Patrick Thomas of Notre Dame Law School. The district court agreed, finding the IRS's policy of withholding stimulus payments arbitrary and capricious and not in accordance with law. It ruled that the IRS was not authorized to withhold payment from incarcerated individuals solely because they are or were incarcerated. It converted its preliminary injunction, issued on September 24, 2020, into a permanent injunction and gave the IRS and Treasury Department 30 days from the initial ruling to reconsider stimulus payments for individuals who are entitled to them based on information that the IRS has from 2018 or 2019 tax returns. Furthermore, the court ordered the IRS to reconsider any claim filed through the non-filer online portal, or otherwise that was previously denied solely on the basis of the claimant's incarcerated status. The rapid pace of the case and summary judgment reflected the strength of the plaintiff's claim and the inherent flaws in the IRS policy. For a case initially filed on August 1, 2020, getting summary judgment in 75 days can make your head spin, wrote Keith Fogg in a blog post on procedurally taxing. Rarely does a case move so fast and so favorably. It helps that the IRS took a position unsupported by the statute and that it inexplicably reached this position after reversing itself, he added. Inmates and their loved ones should move quickly, given the impending deadlines to submit a claim and receive a stimulus check in 2020. Here are some useful tips based on information from a dedicated page, www.CARES Act Prison Case.